Okay, Mr. Trush, which case did you want to take first?
If we could address Mr. Saylor, and then I think Mr. Murthy has a few while I have one over on Otsego.
Okay. All right, so we'll go on the record in People versus Saylor. We have two different matters up. We have file number 245346, and we have file number 2. Oh, no,
I think
file two different things.
Yes, two violations, same file.
Mr.
Your Honor, we would just be asking to adjourn this over to the motion day in August. We have an offer in the underlying case from the prosecutor. Based on my discussions with Mr. Saylor, I think it's consistent with what he is willing to accept. We're set for our probable cause conference next Tuesday in front of Judge Burmeister. Again, my anticipation is we're going to waive the exam. Then we'd be in a position to get all these things up at the same time and resolve them all at the same time. Line up the pleas and the sentencings.
Mr. McDowell or Ms. Coe?
I think that's fine.
No objection, Judge.
Mr. Saylor, have you had a chance to talk to your attorney?
Yes, sir.
Is that how you want to?
Yes, sir.
Okay. So we'll set this out as indicated by counsel. Anything else on this file we needed to address?
No, Your Honor.
No.
Mr. Murthy, were you ready with your case?
I'm ready, Mr. Farron and Mr. Bakshaw, so we can.
Call
either
Mr.
one.
Farron's case first. People versus Farron, file number 265529. Record should reflect Mr. Farron present here in the courtroom today. I do have conflict of your appearance.
Sierra Coke on behalf of the people.
Thank you, Honorable Representative Murthy, on behalf of Mr. Farron. Mr. Farron just said.
Mr. Murthy, I did receive communication indicating that there's been an agreement reached in this case. Is that correct?
That's correct, Judge. There was an amended information filed in this matter. I'll acknowledge receipt of that amended information. We'll waive formal reading of that as well. The agreement is that Mr. Farron is going to plead no contest to head count 5, counts 1 through 4, including the habitual fourth offender notice will be dismissed. And I think it'd be a no contest, but you have a copy of the report to rely on. Yeah. No contest plea, and the reason for the no contest plea is potential civil liability.
Ms. Koch, is that a correct statement of the offer?
It is, and Mr. Murthy and I worked on this case. I couldn't even imagine the dozen of hours we've put in on this case, but I did work with the victim on the plea offer, specifically the guardian, and they are okay with this plea offer. It sort of built a resolution for the mentally incapable individual that would have had to testify next week. She was willing and able to testify. She actually came in on her own, but I think this is the best resolution. It also takes into account all of the factors. So I think this is a fair resolution.
Mr. Farron had an adequate opportunity to speak to Mr. Murthy about this agreement.
Yes.
Is that how you want to proceed today?
Yes.
Raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Mr. Farron, you understand that by pleading guilty, or I'm sorry, no contest to this added count 5, that the maximum possible penalty that you could face would be up to 5 years.
Yes.
That in mind, what is your plea to that charge this morning?
With regards to Tiffany being, I plead no contest to
Count 5.
count 5.
And Judge, if I could interrupt, Mr. Farron is on parole. I've advised Mr. Farron that the sentence will be consecutive by statute to what parole would do. So I think we should make that right.
And also that there would be no jail credit, is that correct?
That's correct. He understands that he's on that time and there's no jail credit. That's correct.
Okay. So Mr. Farron, you had those conversations with your attorney.
Yes, if I could briefly, as well, Your Honor, I spoke with Agent
Well,
Chan.
hold on. You guys just.
I just want to make sure you understand that that is also a consequence of your plea today.
Don't, I would advise you not to divulge additional information that's not necessary. Just answer the question.
Yes.
Okay, thank you. So again, with those things in mind, what would your plea be to this added count 5 today?
No contest.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during the trial and to not have that silence used against you. The right to testify at a trial yourself if you want it. You understand all those rights. Giving up and waiving all of those rights by pleading no contest.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that if you wanted to appeal this plea, you would have to ask for the Court of Appeals to hear that case. They could say yes, or they could say no, and if they said no, then that would be the end of the appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than that you're in court today? Is it your own free choice to enter this plea? Well, first of all, I'm going to identify the police report that I've been provided. It's Crawford County Sheriff's Department. Report number 25120000166. Is that the report that you reviewed, Mr. Gerber?
Yes, sir.
Would you agree that the information in that report would provide a factual basis for finding guilt as to this added count 5?
I would agree.
Ms. Koch, have you reviewed that report as well?
Yes,
Would you agree that it would provide a factual basis?
yes,
All right, thank you. The court is going to mark and admit that report as Court Exhibit 1. Use that as the factual basis here. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
no, Your Honor.
Mr. Gerber, are you?
No,
And Ms. Koch, are the people satisfied that the court has complied with statute, court rule, and the taking of this no contest plea?
Yes, Your Honor.
Mr. Gerber?
and I agree.
All right, Mr. Farron, the court finds that your plea is knowing and voluntary. The court is satisfied based on my review of Court Exhibit 1 that there is a factual basis to support a finding that you are guilty of the added count 5. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Between now and then, Mr. Farron, somebody from the probation department will meet with you to prepare a pre-sentence report. You'll have an opportunity to go through that with your attorney prior to the sentencing hearing. Ms. Koch, is there anything? Oh, and then in light of the plea today, the court will adjourn the jury trial that's currently scheduled for next week. Ms. Koch, do the people have anything further on this file today?
No, thank you, Your Honor.
Mr. Gerber?
Judge, I'd like to be present for the pre-sentence interview for Mr. Farron, so if we can schedule that when the department schedules that interview, Mr. Farron, I'll participate with that.
Certainly. Thank you, that's all.
Judge, I'm ready, Mr. Barsha, for the Colorado case.
People versus Barsha. This is file number 265562.
Your Coke on behalf of the people.
Thank you, I'm ready to go with you. We have Mr. Barsha, who's just stating right.
Thank you. How do you want?
Today's our first jury status conference here on Circuit Court. We're going to ask that we set this matter up for trial, perhaps in the next 90 days, with a plea cutoff and then a trial date after 90 days. That's possible, Judge.
Certainly do that. Ms. Koch, how much time do the people need to be ready for a trial in this case?
We can be ready in 60 days. I know the courts, we're scheduling out a couple of months, so whenever we can get on the docket is fine.
Basically, as soon as it's
That's fine.
But my understanding was that the docket was out about 90 days, so 90 days would be sufficient for us to prepare for trial.
How many days of trial? Ms. Koch?
I think we might actually need two. we might be able to do it in one. I usually get them done in one, but there might be some evidentiary issues. We have some co-defendants that are testifying.
Mr. Murphy, looks like this list is quite lengthy. Is 2 days good for you now?
I'd say 2 to 3, sure, but I think we can get it done in 2 because the defense has identified some weaknesses.
So we'll start for a 2-day jury trial, about 90 days out. And we'll set for a final status conference prior to the trial date, as usual. That will be the plea cutoff and the motion cutoff. So if there are any motions, they would need to be filed under no later date of the final status conference. And then Mr. Barshaw, that'll be your next appearance in court. To the extent that you wanted to consider any plea offers, that would be the last day to enter into a plea agreement. We don't have a plea on that date. We talk that over with Mr. Ready with the final decisions and plea offers on the date, okay. Then the court will send out notice of the trial dates as well as the final status conference. Besides the plea, just make sure you stay in touch with your attorney so that you know it'll be prepared for trial. Ms. Cope, is there anything further today?
No, thank you.
No, you know, I've had good contact with Mr. Barsha, so I have no problem with contact with him, so nothing further.
Okay, Mr. Barshaw, did you have any questions about how we? Thank you, that's all.
But I'm also ready, Mr. Colcom, but I end up bringing, so.
Oh, we have a break, just so everybody's aware, to my right, this is Misha Byers, she's taking LSAT, she's gonna be going to law school, so she's doing some job shadowing. See all you attorneys at work, so.
Quit while you're ahead.
LSAT was what, a lifelong for us.
I know, well, the facility right at mine, like, I could do the test, they lost power, so they had an accident. Ran into a
Oh, wow.
utility pole, so they had to pause it.
Wow.
Yeah. Mackenzie is taking or took the LSAT, Jason's assistant, and she said they don't even have centers for taking it all online.
Well, the August one, the one I'm taking, is the first one where it's mandatory all in person. Because
Oh,
there was a huge cheating scandal in May for the online test, so now it's all in person again.
I like that. I didn't check it.
I was telling Dana, like, when we took the bar, we used blue books. And she's like, you used you used a blue book?
I was the last year that there was an option of typing versus writing. And everybody encourages us to write because the program itself has just been developed. So it crashes and nothing's no big deal, so.
Not me. I showed up with 10 blue books, 300 pencils.
I remember by the end.
She's right here, she's still there. She's over
Paper, then tissue paper, and a book copy. So,
Well, Don was telling me, because he's like, okay, well, I take my notes on a pad of paper. I was like, not in Judge B's courtroom. We have 70 cases in 4 hours. You're gonna need to type and type fast. If you come watch the misdemeanors, they go really fast because there's so many.
On record in People versus Carl Bolton, this is file number 24. Record should reflect Mr. Bolton present here in the courtroom today. Executive counsel, this is on the record.
Eric Hope on behalf of the people.
Yeah, I don't have a good record. Just stand to my right.
Mr. Murthy, I don't know if you're aware, I just want to make sure I make a record of this. Mr. Colcom did submit a note here. It was given to me as dress Judge Burmeister. I don't know if you have seen this or what.
I haven't seen it. I don't mind seeing it, but I can simply stand on the record. I can't represent Mr. Colcom because I have a conflict.
Oh, okay.
I've indicated that to Mr. Thompson and Mr. Trush's office. I think they're just going through the process of assigning counsel for Mr. Colcom. So I really haven't, it would be unethical for me to do any work on it or advise him in any way. I've indicated that to Mr. Colcom as well. He understands that. He's indicated to me that his family might retain counsel, but I don't know what. I can't inform the court anything additional because I didn't want to get into any additional confidential information knowing that I have a conflict. I will advise Mr. Colcom, he certainly can address the issue of bond, which he wants to, but I've asked him not to make any admissions that could hurt his case. And I'll certainly stop him if he gets into those muddy waters of making any statements that could hurt him. But I think in general, he's asking for a court to review his bond and set a bond at this point. I know he's held without bond, but he's asking for a bond to be set.
So first of all, I guess, do you have any objection to adjourning this till we can get Mr. Colcom to sign the counsel?
No, this case has been pending for a long time. I realized that the conflict actually I think just arose this weekend, so it was relatively new information. But we probably can't adjourn it too long because Cynthia's in custody.
Yeah, no, I mean, I would be setting this for my next available date.
I think that's fine, Your Honor.
Okay. All right, Mr. Colcom, I'm certainly willing to hear anything you have to say regarding bond at this time. I don't know if you want to do that or if you want to wait till you have a new attorney assigned to you. How did you want to?
I don't know that I would hurt myself speaking on bond issues. Is that a problem?
As long as you don't make statements that could hurt your case, if you ask for a bond, like I indicated, you could suddenly ask if there's a problem, I'll stop you.
I mean, Mr. Murthy, I don't know what the conflict is and you don't have to make record of it, but would it prevent you from at least advising Mr. Colcom here on the bond issue?
No.
Okay, all right. So, Mr. Colcom, you're currently being held without bond because you've been missing for about a year and a half.
Yes, Your Honor. I was down in Detroit awaiting contact from detectives in Detroit. I was cooperating on a case to help my case. And I did not realize that they were calling and it would be on my phone as a spam call. I was expecting a detective or a county something on my phone, but I never got that. But my wife and I had spent that time in hotel rooms waiting to be contacted, and I didn't realize that I would be in a court case. I would have my date, before I dealt with the detective. So I was just waiting to be contacted down there, and I wasn't absconding. I wasn't trying to run from it. I was trying to cooperate with detectives, but like I said, I did not know that they were going to be calling me, and it would say it was a spam call. So I wasn't aware. I'm not familiar, but at this point, I have an address local that I can stay at if I was released, and I would be, very available, and I'm thoroughly willing to cooperate with whatever requirements or.
My understanding is he would comply with bond conditions. He would comply with the court orders him to drug test and meet with pretrial services. He would do that.
Yeah.
He has a local address that he would be residing at. He doesn't object to being on GPS tether.
Yeah.
The only contact I've had is not with his wife, but his mother, who lives in the UP. She's had good contact with Mr. Colcom as well, and she's reached out to me a couple of times to discuss this matter. So I have contact with his mother, but it's a UP address where she resides.
Thank you. Ms. Koch, anything you wanted to say regarding bond?
I frankly don't think what Mr. Colcom said is a fair representation of what happened. He failed to appear, then he showed up, gave 3 numbers. He was being cooperative, but then stopped and ghosted the people that he was working with on our case. And he had court, he had a lawyer appointed. He could have called anybody. You don't just disappear in the middle of a delivery case and then act like it's everybody else's fault. I think that's inaccurate. The charges here are pretty serious. He has failed to appear more than once, actually. I did amend, I think they're 2 PWID cases under 50. He doesn't have very much of a criminal history. He has a use of controlled substance and an impaired both in 2023. There was a fairly significant amount of drugs. I made an offer in this case. I still think a high cash bond is appropriate. I'm not convinced if he's released, he's going to show back up again, given that he's failed to appear, for almost 2 years, but.
Okay, so Mr. Holcomb, I mean, your explanation for not appearing in court and not contacting the court or your attorney for a year and a half doesn't make sense. This case wasn't going away. There's no reason why, for a year and a half, you should have ignored what was going on here in your case in 46th Circuit Court. And so what that means to me is I don't have any assurances that you would stay local, that you would appear for future hearings.
I invested highly in cooperating with the detectives as
Yeah,
far
so
as they would need.
you can cooperate with the detectives in Detroit all day long and still appear for your case here.
Well, I wasn't aware how things work as far as that kind of investigation thing goes. I'm not familiar.
That, none of that would stop you from reaching out to your attorney here and say, hey, what's going on with my case in Crawford County?
I understand.
So if you didn't do it then, I have no reason to believe that you would do it now. So the court is going to continue to deny bond based on your failure to appear. Once you're assigned new counsel, I certainly would consider further arguments of your new counsel if they're able to develop different facts by talking to you. But as it is now, we'll go forward. You will remain lodged until the next hearing. A new attorney will be appointed to you. You have a chance to talk to that person. If you decide that you want to hire your own, of course, you're free to do that at any time. So that's all for today. Thank you.
Just, do you need an order? I don't know if it just gets assigned that covers, keeps the file clean, or
Yeah, I think that's all handled through
MIDC. So you don't need an order for me to prepare and send over, right?
There's one needed. I would think Mr. Thompson would prepare it.
Okay. All right. Thank you, Judge. Thank you. I think I'm all set for the morning, Judge.
All right.
Thank you.
Okay. Mr. Trush is still on records with Judge Hunter. He's double booked unfortunately this morning. So we're going to take a short recess. We'll come back on the record. Trish, which case did you want to take first today?
We can address Mr. Bott, you just walked in.
This is file number 265551. Versus Bott. Oh, I'm sorry, 265544.
You're at Cogan, behalf of the people.
Thank you, Your Honor. Richard Trishman, on behalf of Mr. Bott.
How do you want to proceed in this file?
So, Your Honor, we do have an agreement for the court. It would contemplate a plea to an added count 3. That is possession of a narcotic less than 25 grams. That is NCL 333-740-3285. That being the 4-year offense. Counts 1 and 2, as well as the habitual second offender notice, will be dismissed. In addition to that, the prosecutor has indicated, if eligible, they're not objecting to treatment for 7411. We do believe he will be eligible for that.
And are we taking the factual basis to the methamphetamine?
We will be taken to the higher charge.
Ms. Koch, are the people in agreement with the recitation of the plea?
Yes.
Mr. Bott, have you had, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes.
Is that how you wanted to proceed today?
Yes.
Here's your recommendation. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yeah.
Mr. Bott, are you currently on any kind of probation or parole?
No.
And to your knowledge, have you ever been convicted of a prior controlled substance related offense?
No.
And you understand that by pleading guilty to this added count 3, possession of narcotics at the maximum possible penalty you would face would be up to 4 years.
Correct.
With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Understand all those rights?
Yes.
You understand that you're going to be giving up, waiving those rights by pleading guilty?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that? Correct. Has anyone threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what was said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates this happened back on August 11th of last year, 2025. Is that the correct date?
Correct.
Your Honor, may I assist with the actual basis? On that date, were you here in Crawford County?
Correct.
And were you operating a vehicle?
Yes.
And in that vehicle, were there some pills?
Yes.
And at that time, did you believe those pills were Adderall?
Yes.
And you now today know that some of those pills were methamphetamine?
Yes.
And you didn't have any authority to have any methamphetamine on that date?
No.
I think that would provide a basis for the higher charge to apply to the lower charge.
I would agree, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute for the undertaking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Bott, the court finds that your plea is knowing, voluntary, and accurate, or to satisfy that there is a factual basis to support a finding that you are guilty of this added count 3, the court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with one of the probation officers to set up a time for a pre-sentence report. Once that's prepared, you'll have a chance to go through that with your attorney prior to the sentencing hearing.
Okay.
Did you have any questions? Oh, I'm sorry. Just for the record, this is currently set for trial on August 13th in light of the plea. We'll return that trial date.
We have Mr. Bowman.
Versus Bowman, file number 265551. Bowman is present here in the courtroom today. Want to proceed in this file?
Your Honor, in this file, we do have an offer that we would intend to accept. It contemplates a plea to count 1, possession of methamphetamine with the dismissal of the habitual third offender notice. We would seek to take advantage of that today.
Ms. Koch, is that a correct statement of the plea offer?
Yes,
Mr. Bowman, have you had an adequate opportunity to talk to your attorney about this plea agreement?
It's about my minions, I have.
Yes. Okay. All right, you have.
Yes, sir.
All right. And did you want to proceed with that plea here today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Baumann, are you currently on any kind of probation or parole?
Yes.
Where is that out of?
Can't count.
Do you know whether or not this plea today is going to result in a violation of that probation?
I do not.
You understand that it could result in a violation of that probation in Kent County and that they could issue sanctions that are in addition to any sanction that you would receive here in this case.
Yes, sir.
And then the charge that you're pleading to here is possession of methamphetamine that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine.
Yes, sir.
So with all of those penalties in mind and potential penalties, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear that case. If they said no, then you wouldn't be able to go any further with that appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here in court tonight?
no, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this charge because you are actually guilty?
Yes, sir.
The information I have indicates this happened on March 9th of 2026. Is that the correct date?
I believe so.
On that date, were you here in Crawford County?
Yes, sir.
And while you were here in Crawford County at that time, did you have possession of some methamphetamine?
Yes, sir.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to have any amount of it at that time?
No, sir.
Ms. Koch, are you satisfied with the factual basis?
yes,
Mr. Truce?
Yes.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
no, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute, court rule in the taking of this plea?
Yes,
Yes, Your Honor.
Thank you, Mr. Baumann. The court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with one of the probation officers to set up a time for pre-sentence report. Do you have any questions?
No, sir.
Thank you. That's all for today.
Thank you.
You ready with Ms. Sanford's case?
I do not see Ms. Sanford here in the courtroom, but I would note, I think we're either 15 minutes or a half hour past our schedule.
Yeah, okay. Let's call that file, People versus Marcella Sanford. There's Ms. Sanford here, please come forward. This is file number 265543. If I could have counsel to your appearance on the record.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Sanford.
All right, as Mr. Trush indicated, this hearing was set for 9:15. It's now 9:48 by my clock. Nobody's answering the call of the court here today. This was set as an in-person hearing. Have you had any contact with Ms. Sanford about it?
I have had contact with Ms. Sanford at various points in the last month. I think our communication has been okay. It's primarily been through email. I've tried to get her into the office, but have not been successful with that. But I would indicate I do not know what her intentions were today. She was never clear to me if she intended to proceed to trial or avail herself of the plea offer.
Your Honor, she did fail to appear on 5/18, but she called the jail and said she couldn't get into Zoom. So the court set a show cause and adjourned it for the in-person. We had that show cause on 6/4. We discussed that I'd be withdrawing the plea at the next hearing, and she indicated that she wanted to discuss the plea offer with her family. And then this court date was set.
Just for the record, she hasn't tried to join by Zoom either, but the court did make it clear, I think, last year. She needed to be here in person today. Things considered, and with Sanford, at least the second time now that she's failed to appear for a hearing. So the court will request that you prepare a bench warrant for Ms. Sanford's arrest. We'll proceed further with Ms. Sanford's case once she's brought to court.
Thank you, Your Honor.
Are you ready on Mr. Roby's case?
Mr. Roby requested that I have a minute to speak to him before we go on the record. So if we could address Mr. Love's case.
People versus Love. This is file number 265536. Courtroom today.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Love.
This is the date and time set for sentencing in this matter. Mr. Love, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
I got a pre-sentence report from Richard here, and I did go over it for you.
Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
I don't believe so, Your Honor.
Oh, do you have any additions, deletions, or corrections?
No,
Any challenges to the scoring?
no.
I did receive a note, Ms. Coe, that one or more of the victims were going to join by Zoom. And this was set for 9:45. We're now 6 minutes past the time. I don't see anyone in the Zoom waiting room. Do you have anybody in the courtroom?
No, we weren't really sure about whether or not the victim was going to appear. He's talked to our victim advocate, but he is not present today.
And I do know that there was a victim statement of the PSI that I did review. But again, I don't see anybody present, so we'll proceed here. So anything on behalf of the people for allocation?
Yeah, I've been dealing with Mr. Love in my professional capacity here for most of my career. He is very nice when he is sober and taking his medication. When he is either abusing substances or has mental health issues, his behavior is very crazy in terms of his things he does. And we've had an arson case with him. This assault was very bad. The victim in this case was very scared from the very beginning. He thought Mr. Love was going to come back and kill him. He thought he had to move. He has panic attacks. Mr. Love has prison guidelines, primarily because of his history, but also because of the type of crime this is. I think the recommendation is a prison sentence is appropriate. And I think the court should follow it. Thank you.
Mr. Trush?
Thank you, Your Honor. I'm very familiar with Mr. Love as well. I've represented him on a few occasions in the past. I think the prosecutor's assessment here is accurate in terms of Mr. Love. I think he presents when he is on his medication and addressing his mental health issues in a very reasonable, good way. Right? He's a good person when he is on his medications and addressing that issue. Unfortunately, when he's not, again, he does things that are problematic, things that bring him here. Through this case, I've watched as Scott has tackled some of these issues with community mental health. And I mean, I've had meetings with him in my office where, he has looked at me teary-eyed and told me that, he goes in there and he gets his medications. And, the longer between the visits, the medications stop being so effective. And when he goes back in, they adjust his medication dose and it's effective. And as he progresses on a little bit, it becomes less effective and he's holding it together. And again, he was very emotional when he talked to me about this and about how hard he is trying to address these issues. And, he's working with CMH, with the doctors there to address them. And frankly, I think he is putting forth an admirable effort. He is really engaged with them and really working hard. It is truly unfortunate. He did an intake for a community mental health diversion program that we were planning to present to Your Honor. Unfortunately, about a week ago, the person who runs that program quit. And CMH has decided they're not going to replace that person and they're not going to continue that program. I think it's really unfortunate because frankly, I don't think MDOC is the right place for Mr. Love. I think in MDOC, the two problems that he grapples with that bring him to court are going to be present for him there. And I think it's going to be hard for him to avoid them there. And that is, I don't think he's going to get the quantity of mental health care that he needs. And it's unfortunate, but I think that is a negative for him. And it's not just a negative for him, I think it's a negative for the community, because what it means is somewhere down the road, if Your Honor follows the guidelines, maybe 2 years, 18 months down the road, he's going to be released, and he's going to be released in a situation that is probably worse than he's in now. And that's bad for the community. I also think, again, in MDOC, we like to pretend that it's forced sobriety, but I mean, it's an illusion. There are substances available to him in MDOC. It's going to be around him. Even if he's trying to avoid it, it's likely it's going to be in a cell block. With that in mind, I don't have a good answer for the court as to what the right response here is. In a perfect world, we would be able to get him into a mental health program like the CMH diversion, where he can have the quantity of care that he needs and he can live a normal life. I think Mr. Love will tell you there's nothing that he wants more than to have a normal life. And I can't think of anything more terrifying than not being able to trust your own mind. With that in mind, Your Honor, I mean, the guidelines are where they are. I would suggest to the court, I think his unique situation requires a more tempered hand. I would suggest to the court that there will be more supervision and more care that could be provided in a community context as opposed to MDOC. Thank you.
Thank you, Mr. Love. Anything that you wanted to say?
She covered it. Thank you very much.
Mr. Love, I did read through the report, so I'm familiar with this incident that occurred, and the facts of that and the injuries that he caused. The severe assault that you committed on this other person because you believe that this person had some kind of romantic interest in your girlfriend at the time. And I'm also familiar with your past history and your circumstances. That's all contained within the report. Of course, Mr. Trushby, through his allocution, some additional information about you. And so I take all of that into account along with what Ms. Cope has had to say and what the victim who isn't speaking here today on the record, but did submit a statement that I read about the effect that this assault had on him. Certainly, I don't think there's any question that you have mental health issues. There's been a lot of attempts in the past over time to help you with that, even through the Department of Corrections on parole from here. That's the role you were assigned to, a different type of role that tries to address mental health issues.
I was.
You've got a history of assaultive crimes. There's numerous assaultive crimes in your history. And there have been attempts through probation and community sanctions to help correct that. But those things, haven't been successful so far. And I have no doubt that your mental health condition contributes to your behaviors and the assaults that you commit. But for the person who's being assaulted, they don't really care what's going on with you or why you're doing it. They just know that they're being injured severely by your conduct. And so it is a difficult situation because if we could correct mental health issues, then maybe you wouldn't commit the assaults, you wouldn't be here. At the same time, after efforts have been made, 5 times on probation, 5 prior jail sentences, what can we do this time that's going to be any different than what has been done in the past and hasn't worked? And you continue to assault people and injure people, and at some point the court has to have an overriding interest in the protection of public safety. And at this point, the guidelines call for prison guidelines. I think your behavior in this circumstance certainly warrants that. And with the harm that you cause to this other individual, both through the assault itself and the trauma that that person's going to carry with them, deserves a degree of punishment. So, but I do find that a sentence within the guidelines is appropriate. The court is going to send you guidelines that are 19 to 38 months. The court is going to send you 30 months, Michigan Department of Corrections to 10 years. You have credit for 2 days served. The court is going to order restitution in the amount of $880 that's payable to the Crawford County Clerk, to be dispersed to the victim as reimbursement for his medical care costs that resulted from the assault. Assessment of $130 for costs of $325, attorney fees of $50, and $68 state costs. You have the ability to seek an appeal of the sentence. Mr. Drew should be provided health rates to.
Can you give me my paperwork, my PSI report and stuff, to get it to me?
Yeah.
Ship it over to me.
Yeah, it'll probably take a few weeks because we'll have to mail it to the facility.
Okay, yes, thank you.
Yeah, Mr. Thompson, and then I'll move on to some of this document while you're speaking. Mr. Wilkie. So, Thompson.
Yes.
Are you ready on Trombley?
Yes, Mr. Thomas.
Versus Sean Trombley, file number 235197. Like Mr. Trombley's present here in court today. I get counsel for your appearances.
You're a cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Sean Trombley.
I have this down as a sentencing, but I did not get.
The court should have one from March, so it's a little bit of an odd procedural history. I can kind of,
Yeah.
I think, walk us through this.
Let's do that, please.
So Mr. Trombley pled guilty to a probation violation. The court set a hearing on April 9th to do a sentencing, Your Honor. Mr. Trombley was ill that day, did not appear. The court issued an order dated April 10th that indicated that based on his non-appearance, the court wanted him, or ordered that he be lodged for 90 days, which was his abeyance time on the original sentence.
Okay.
Court indicated that this sentencing hearing that we're here at today should be scheduled within 90 days. I think the court was thinking of, he was going to be in for 90 days. Today's, I think, 89 days, but with good time, he's out. So I don't think that all worked out exactly how maybe it was intended on April 10th, but he is appearing today. And
Okay.
so we are here for that sentencing hearing that was originally supposed to be April 9th.
Mr. Felder, do you have a copy of that original PD? Yes,
I have one.
They just didn't get that.
It'd be plus 61 days added to, I think it was 3 on there before.
Okay.
So I would have that at 64 days credit.
That's how much you got for the 90 to 60.
You got 61, right?
All right, Mr. Thompson, do you need an opportunity to go through this report with your client?
I already had it, Your Honor. Thank you.
Okay. All right. Mr. Thompson, are there any corrections other than the jail credit?
Just,
Ms. Cope, is there any corrections from your standpoint?
No.
And today for allocation.
I would, in some ways, I'll defer to probation staff. This case has been kind of a nightmare the whole time. There's just been multiple violations. From the very beginning, he violated bond almost immediately. Once we started the case, he failed to appear for drug testing. We tried to set it for a jury trial, but he failed to appear. He has done poor on supervision. I think he shows up for court and follows it whenever he feels like it, and otherwise we're just here. I'm not sure probation is the appropriate response for him.
Mr. McDowell, was there anything?
No, nothing aside from my report, Judge.
sorry, Your Honor, if I could go back to the credit, I think if the court ordered him 90 days on this file and he served that, I do think he should be getting 90 days credit. Or else I don't think it'll work right with that. Because I think it was this file that the court ordered those 90 days on. He did serve.
Well,
He didn't serve, he served 61 days.
yeah, I mean, I don't know.
If he's set on his new sentence, he will, whatever judge sentences him to, that'll compute his good time off that.
But if it's the same file, I'm just concerned, we don't have to include that 90 as part of the sentence.
I think what you're saying is there's a difference between the actual jail time he served and whether or not his good time would be computed into the court's ultimate sentence.
Right, I mean, obviously, if the court gives him additional time, I would understand, that's within the court's discretion, but we don't have to include the 90 he already served today when we're doing the sentence.
So I think the solution to this is exactly what you said, Mr. McDowell, which is if I were to order extra time, then the good time he's had will continue and take that time off of the full sentence, not just the 90 days.
Okay.
So
All right, and that's all I'm looking to do is, is make sure the numbers are correct in his favor. Right. We'll work on what they're supposed to. We are asking the court, Your Honor, today to consider releasing him on time served here on that 90 days that he served and did his 61 days on, Your Honor. The recommendation is a unsuccessful discharge. We understand that. The recommendation is within the original sentencing guidelines, which is 0 to 17. Mr. McFall had suggested 6 months earlier. 3 months was tremendously beneficial for Mr. Trombley. He appears before you today. He's significantly healthier. He looks much better. He advises me he's working. He's working for some elderly people in the area, doing odd jobs and running errands, doing lawn care and doing things like that, making himself useful. This is going to be an unsuccessful discharge. We understand that, but we'd ask the court to consider sentencing him to the time he has served thus far, which is part of why I'm worried about the days we write down. But we understand it's within the court's discretion. Mr. Trombley apologizes for what happened with his agent last November. And again, it's going to be an unsuccessful discharge. So he just wants to put this behind and move forward, be a productive citizen, and be as healthy as he appears today, which is significantly better than when he has been using in the past. Thank you.
Mr. Trombley, anything you wanted to say? All right. I did have a chance to review this report here today while we've been on the record. I did receive it previously, had an opportunity to review that then as well. Of course, I'm familiar with your case. I sentenced you originally in this file, so I'm familiar with the factual background of the original charge as well as what's happened while you're on probation. The report indicates that Mr. Trombley did pay his fines and costs. Is that interesting?
I don't have a report. That's what it says in there that he's paid for. Yes.
Right. So, there were certainly some failures while you were on probation. However, the fact that you did make payments and pay off your financial obligations is something that I have to give credit for as well. Looking at the underlying charge, which was a possession charge. Number one, I find that discharge from probation unsuccessfully is absolutely appropriate. And it's going to continue on probation. I think either you or the community has much to gain from that. And in terms of jail time, the court had originally sentenced you to 90 days of jail and held that time in abeyance. You've since served that based on violation. And as with continuing on probation, I don't have any reason to believe that additional jail time is going to be beneficial for you or the community. So, and again, I think you're entitled to some mitigation that you can pay off all your fines and costs. So the court is going to sentence you to time served. The court is going to order that you be discharged unsuccessfully from probation and that 7411 status be revoked. There are no fines or costs to preserve. Mr. Thompson, if you could provide, Mr. Trombley, you do have the right to appeal this sentence should you wish to do so. Those papers are going to seek an appeal as well as how to request a court.
Thank you, Your Honor. Mr. Trombley has executed that, provided to the court clerk. Here's to keep. Throw away.
Mr. McDowell, is there anything else Mr. Trombley has to do with your office?
Nope, all set.
All right, thank you.
Thank you.
You're all set.
Ready on Mr. Roby's case.
Yeah, sure.
Protocol People versus Roby. This is file number 265520 and 5564. The record should reflect Mr. Roby's presence here in the courtroom today. This is the date and time set for sentencing both of these matters. Mr. Roby, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Church about that?
I have, Your Honor.
Your Honor, there is a child in the courtroom associated with Mr. Roby. I don't know if she wants to have him step out.
Something you want your child to see. All right,
Thank you.
Mr. Truce, are there any additions, deletions, or corrections to that report?
There are a few, Your Honor.
Okay.
So to start with, on CFJ 145, page 1, it indicates pending charges. It says there's pending charges in Grand Traverse County. Those charges have been dismissed. I have a copy of the Nolly Pros for the court if the court wanted it, but those charges are not pending.
Okay, Ms. Coe, any objection to that change?
No.
Okay. So let the PSI reflect that those drivers have been dismissed.
Going to the adult criminal history section, entry 21 of 23, and that's this charge. This indicates in here an aggravated domestic violence with a habitual second offender notice. I just want to make clear, I think that's inaccurate. It's a second offense notice, but it's not a habitual offender notice.
So
That is correct. I mean, it is an ADV second offense notice. I'm not sure if they wrote it in there incorrectly, but the staff will get it fixed.
okay, so we'll just have that corrected to second as opposed to habitual under enhancement second. Any other corrections?
And then CFJ 284, page 16. And I'm not sure on this. It indicates in the section under gang marks, scars, and tattoos. Mr. Roby does have a tattoo on his leg. He indicates it's not a gang-related tattoo. I'm not completely sure if that's what they're suggesting, but he indicates to me that he has no gang affiliations.
I think that's just the section that goes into, I don't think it means a gang. It could be either or in that section.
I mean, I read that to be gang related. That's why it's in a different section than marks, scars, amputations, and tattoos as they are.
Okay.
To me, the purpose of those three entries are to let the court know whether the defendant has anything, a scar, brand, that kind of thing, or a tattoo that would affiliate him with. So he's saying no. Is there, do you have any reason to believe that it is gang related other than?
I do not.
So that information is contained, the fact that there's a tattoo there is contained on the outside, so strike that.
There's quite a few things in the, and I'm on CFJ 284, page 17, just the personal information, like his employment history and stuff. It might be easier for me to just provide that information to Mr. McFalda. So like he has rates of pays for different things and just that aren't included in there right now. I think it'd probably be easier for me to just provide that than to go through it line by line here.
You got things to supplement what's in there?
Yes. And what I think happened is it was carried over from a prior PSI and some of the information just isn't accurate or isn't in there.
Do you have any objection to that?
I don't. I have no information about his employment information. I would suspect that the information he'd provide would be more accurate.
And then in the last correction, on the very last, so CFJ 101.1, that's the basic information sheet. It indicates 3 adult prison sentences. Mr. Roby indicates he's only been to prison twice. I think that the issue here is one of the times he was sent to prison, I think he was sentenced in 2 cases to MDOC, but he's only been to prison twice.
Okay.
I'm not sure how the court addresses that, but I think there were two sentences that basically ran concurrent.
Separate sentences and separate file numbers, but he served in the same.
Yeah,
And I mean, I think the basic information report is correct in that regard, that it was sentenced 3 times. So
and that's why I said I wasn't sure about that, but Mr. Roby had raised it to me.
I'll take that certainly take that into consideration, but I don't think it makes that basic information report correct.
Understood. That's all the corrections that we had.
Do you have any challenges to this scoring?
We do not.
Scope, do the people have any additions, deletions, or corrections?
No.
Do you have any challenges to the scoring?
Your Honor, I do think the OV is scored wrong on the domestic violence. I did not file a written objection as I'm required to. I didn't see it until I read through Mr. Roby's letter and went and checked it again. It's just a failure to appear. You have to score OV 19 when someone fails to appear. He did fail to appear. It actually led to an absconding charge. He failed to appear twice, but one time he was in court, he was in jail somewhere else. He failed to appear on 5/7 in front of this court, and the court entered a bench warrant. So if the court wants to dismiss my challenge because I didn't file the objection, I understand.
What effect would that have on the guidelines?
It changes it from 12 to 24. It moves it from category 2 to category 3, and it changes it to 14 to 29. It's not a substantial change. It just probably should be right.
It absolutely should be right.
Your Honor, I'm not sure that I'm really prepared to answer that because again, I don't have the information for what the alleged missed court dates are. Candidly, again, I know that there were bond violations that occurred. I know that he was in Traverse City's jail for a period of time. So I'm not really prepared to respond to that in terms of if there's an allegation that would meet the criteria for that.
All right, I guess, number one, it's not completely uncommon occurrence that somebody fails to appear for court and bench warrants issued. I don't know, as I sit here, whether or not OB-19 is scored in all of those cases or not. And I don't have any authority in front of me that says it must be scored under OB-19. So to the extent the argument's made here, the court finds it's insufficient for the state period through.
Thank you.
Challenge that. So it'll remain scored 12 to 24. Did you have any other issues with the PSI, Ms. Koch?
No.
Okay. So Ms. Koch, I did receive a letter from Shavikas. I did receive a letter from Ms. Shavikas that I had a chance to review prior to the hearing today. Ms. Koch, whether she wants to make a statement.
I think she does want to speak.
Ms. Shavikas, did you want to speak at today's hearing? So Mr. Roby, if you and Mr. Trush can be seated there at the table, please. Ms. Shavikas, you can come forward, perhaps to the podium there. Got your name already here on the record. As I said, I did read your letter. Is there anything else?
I think that the letter really pretty much states everything that I feel about this. We're both at fault of being alcoholics, and I have come to the understanding that I was, and I have been in AA, and I've been sober for over 30 days now. And I feel like I was dragging Joe down because I refused to see that I was an alcoholic, and he was asking me to go to AA classes with him and everything, and I refused it. But now that my eyes have been opened to it, I feel like maybe he was correct at that whole time. And two alcoholics dragging each other down, it's never gonna amount to anything good. And I most definitely antagonized. And it's not okay that he put his hands on me, but at the same time, he was very unaware of what he was doing. And as was I. I did have a weapon on me at the time, which I didn't even realize that I had. I do feel like the time he's put in is well over what should have been done for what happened. I feel that following up with AA and maybe even counseling would be great. I do still care for him. I love him. And I do wish to marry him at some point, but I want us to be both sober for an amount of time, at least a year, clean and sober with nothing. And I hope the court understands that and takes it into consideration.
Roby and Mr. Truce, you can come back up to the podium, Ms. Coe, do you have something else that you want to say for now?
Your Honor, Mr. Roby's PSI sets forth how terrible these DVs are. The Grand Traverse one was dismissed as part of our plea agreement. In this case, I talked to the prosecutor over there and talked to her about what was happening in these cases. These were so bad, these different things that other people were calling on them and telling what was happening. I'm not surprised that Leanne stood up today and said those things. We've talked to her throughout the entire case. We have tried to explain to her that this is a very toxic and dangerous situation. She refuses to leave. We just kept having multiple violation after multiple violation, all of which involved them both being, using alcohol to levels of major intoxication. Mr. Roby's criminal history, frankly, speaks for itself. It is long, it is riddled with substance abuse, and I think he has a negligent homicide on there. I checked the scoring. I thought it was scored correctly, but when you look at how many times he's been through the court system, the reason we have community sanctions, which is jail and probation, is for people who want to do well on probation and it's people who want to have a chance. Mr. Roby has had 3 cases that have had prison sentences. I understand he only went twice, but he has 15 misdemeanors, a juvenile record, 4 felonies. He's only 38 years old, and these are very violent offenses. During these attacks, Leanne said to law enforcement that she thought he was going to kill her, that he threatened to kill her. And then in her PSI said she thinks he should get time served and she wants to marry him. She had strangulation marks on her neck. These cases were terrible, and he frankly did terrible when he was on bond. He didn't follow the conditions. He didn't show up for court. Nothing about Mr. Roby's criminal history or his behavior during any of these cases indicate he is a good candidate for jail. MDOC guidelines are appropriate. They're 12 to 24. They start at the bottom being the max jail sentence. And frankly, nothing about his behavior indicates he should be put in jail. I had asked the court to sentence him to the high end of the guidelines. Thank you.
Thank you, Your Honor. I agree with the prosecutor on at least one point here, and that is that I think that Mr. Roby's history does paint a very clear picture. I think it paints a picture of somebody who has struggled with substances. I mean, you can go back to his juvenile history all the way through here, and what you'll see in his history is substance. But what you won't see in his history is, prior to these events, anything of an assaultive nature. I think you'd have to go all the way back to a juvenile case in 2002 to see anything that even suggests assaultive nature in his history. Mr. Roby will tell you here today, he is an addict, right? He has addiction problems and he has struggled with it. And he's had periods of success. He's had periods where he struggled. Frankly, he has helped other people to get into treatment programs and get sober. Unfortunately, he should have taken his own advice and done the things that he was helping other people to do, but he wasn't there yet. And he wasn't ready for it. And we see that, right? We see people who aren't ready to make the change. Mr. Roby indicates to me, I think this is his rock bottom. This is the point where he has, done something that he is truly ashamed of. Something that, when he looks at himself in the mirror, doesn't like what he sees. And again, from talking to him through this, from the start of this to the point where we tendered a plea to where we're here before you today, I've seen some of those changes. The change in his demeanor about this, right? How he talks about it, how he speaks about what he wants to do. And it's changed. I think, and I hope that this is rock bottom for him and that he makes the changes that he says he wants to do. He has the tools. He knows how to do it because he's helped other people to get there. I would suggest to the court, if we want people to engage in treatment and we want people to make the changes, we can make it easy, right? We can give them the easy choice. Certainly, he always had the opportunity to go into a treatment program. He could have done it at any point before he's in the jail. And the court often identifies that, right? There's nothing that stopped you from doing this. But to the extent that we can make the choice easy for him, right? If the choice is you sit in the jail or you go into a rehab facility, right? That's a very easy choice to make, right? We've made it very easy and accessible for him to easy for them. I think the recommendation here is appropriate. If the court were to sentence him to county jail and give him an opportunity at the end of that sentence to go into a rehab facility, we set him up for success. We make it easy for him to make the choice to get the help he needs, and we make it so that when he's released, he's set up for success, right? He has a firm foundation to work from instead of being released right back into the same mess. The court would have supervision on a probationary term. It makes a lot of sense for that. Mr. Roby has experienced through MDOC in the past, where he's had his outdates, his parole denied repeatedly because he couldn't get into the programming that he needed, I think during the COVID era. We can make the programming that he needs and is ready to engage in available to him almost immediately, right? We can make it an easy choice for him. And I would ask the court to follow the recommendation here and consider, again, allowing him to enter a treatment program at the end of the jail sentence, the last 30 days, 60 days, so that, again, when he leaves, he has that firm foundation. Thank you.
Thank you. First, Your Honor, I'd like to apologize for missing court on May 7th. I've never missed court before, and I truly did not mean to. The one that I missed while I was in Grand Traverse County, I'd like to explain that, but you don't want to hear about loud sex in a hotel room. You can ask Ms. Shabikas. I'm not lying. I'll go grab the paperwork out of my cell. You don't want to hear about it, so there's no explaining it. May 7th, my fault. I was homeless. I missed it. I'm sorry, sir. Second, I love Leanne with all my heart and soul. I've struggled with substances most of my life, mainly alcohol, and my history's littered with it. You can see my file, sir. I'm ashamed to know that I hurt someone I love so dearly. I'm at rock bottom. I'm sober now, and I know I need to change. I've expressed this to you in court before. You told me that you would help me, allow me to rehab as part of my sentence, but you told me I had to be locked up for a minute first. I understand I'm not going home today, but would like to ask you to follow the Department of Corrections recommendation and give me a county sentence and help keep me local for one reason, to see my unborn child be brought into this world and allow me to go to rehab at the end of the sentence so I can become the man that my family needs to be. Leanne and my stepchildren are my life, as well as I'd like to ask for no contact order to be removed so I can be granted the furlough for my child's birth, as well as be able to be there emotionally for my partner without the thought of, let's get this different phone number, let's get that different phone number so we can get around that and still try to be there and worry about, damn, I'm in trouble now because I got caught trying to be there for my partner. You know what I'm saying, sir? I love this woman with all my heart. I don't want to lose her for my life. Okay. I want to be able to be there, not like only emotionally, but like physically support her, take care of her when I'm released. She's my everything. I don't want to lose her. If you're willing to lift a no contact order, give me the MVOC recommended county sentence. I promise you, you'll never see me in this courtroom again. That's my word as a broken man on rock bottom. I'm asking for help. Please help me help myself, be the man my family needs me to be. This beautiful woman is all I have left in this life. I don't want to lose her because of, like she said, drunken stupidity. Like, I'm sorry, she pulled me off my square. Since 2017, when I got home from the drug charge, I've been helping people get sober. A little bit of drinking here and a little bit of drinking there, but I've been getting people off of drugs at my own cost, taking them to my home. Honestly, I never intended to fall in love with her. She was just another person I intended to help. And we fell in love. Unfortunately, two people that just, you know what I'm saying? The two people with the same problem can't. And you know what, I don't know how to explain it. We ended up harming each other, you know what I'm saying? We both fell into the bottle really hard and it just, things happen, sir. I'm ashamed. I really am, but if you'll give me this county sentence and allow me to go to rehab at the end of it so I can go home and take care of her, and she's pregnant right now. I want to be there for my child's birth and I want to take care of her. Her and that little boy you just saw sitting next to her, Sebastian, my stepson. I love her. This is my family, so this is all I have left. I've lost my home and everything I have in it. I had to sign my dogs over to the animal shelter. This is all I have left, sir, please. Last time I went to prison, I was only supposed to go for 8 months, right in the middle of COVID. I sat there for 3.5 years waiting on a class. No tickets whatsoever. You can look at my file, no tickets whatsoever. I behaved like a good person. And I sat there for 3.5 years waiting on a class. Please, I am scared to lose my family. Can I please have a county sentence so I have a guarantee that I get to go to rehab and go home on a certain date, sir? Please.
Okay. Mr. Roby, I did go through the report, so I'm familiar with why you're before the court here today. There's also a lot of information in that report about your background and your history and so forth. So I'm familiar with all of the circumstances here. I've listened carefully to what you've had to say, what Ms. Shavikas has had to say, and what the lawyers had to say. And so the court has to fashion a sentence here that addresses a number of different things: public safety, punishment for your actions here.
I understand.
And when I look at this report, you know, whether you both were using alcohol or not, whether Ms. Shavikas was antagonizing you verbally or not, the report is pretty bad. What it says that you did. It says, and this is what Ms. Shavikas reported at the time, which I think is more credible than anything that's being said later. Upon leaving, Roby became upset over misplaced belongings and ordered her, Ms. Shavikas, to return them. When she returned to the vehicle, Roby grabbed her by the throat, forced her head into his lap, and bit her cheek. Then he choked her, causing her to lose consciousness. She reported waking up, experiencing breathing difficulty. Upon returning home, Roby acted violently, flipping the coffee table, damaging a television, and pushing her into broken glass, resulting in a cut finger. He forced her to the ground, sat on her, strangled her with one hand, covered her mouth and nose with the other while threatening to kill her. He made multiple death threats throughout the incident. That's the first time.
It's all fabrication.
I'm sure.
It was all a story.
I'm sure none of it happened.
I'm not saying no.
Then the second incident,
fabrication, sir.
second incident, while you're on bond for that, someone, a third party, calls and reports that you've been slapping her around in public. Ms. Shavikas revealed that during an argument, she attempted to walk away from you on Billman Road, hardly antagonizing you when she's trying to walk away. You followed her, shoved her to the ground, then picked her up, threw her down a second time. Officers observed visible injuries, including bruising, a lump on her head, a small cut, and a bleeding finger. This is when you weren't even supposed to have contact with her. You're on bond for the first incident.
Your Honor, she was wasted and I wasn't throwing her down. I was trying to help her up. She blew a .02 12 hours later and I blew a .087 at the scene. She was wasted. I was trying to put her in the car and tell her to take her ass back and go to sleep. She had court the next morning. She was absolutely wasted walking. She bounced from side to side on the road, dude. I did not throw her down or there was none. I'm sorry, statement of a drunken female, sir. A male drunken female, I'm sorry, you can ask her, she'll tell you.
Sorry, I just don't.
I know, nobody
Get
does.
injuries like that on their own. And I think acting that way towards another person, particularly your partner, under these circumstances, doing it multiple times on multiple occasions when you're on bond, shouldn't even be having contact with her in the first place.
When she follows you around the state though, sir,
Yeah, I listened to everything you had to say.
sorry, this is.
And frankly, nothing you have to say here is gonna help you out anyway. Because the facts are what they are. And the fact is that you beat this woman on multiple occasions. You weren't supposed to have contact with her in the first place, and that doesn't give me any kind of confidence that sober or not, you're gonna behave in the right way towards her. I think the sentence at the top end of the guidelines is absolutely warranted in this case, given your behavior. That's what the court is going to sentence you to as to each charge. The court is going to sentence you to 24 months, charge 1 to 5 years. You do have credit for 129 days served. On that one, the court is going to order a crime victims assessment of $130 and a $68 state cost. As to count 2, 24 months to 4 years in the Michigan Department of Corrections with a crime victims assessment of $130, court costs $325, attorney fees $350, and $68 state cost. And if I didn't say you have 58 days credit on that file, those files to run, sentences to run concurrent to each other. You do have the ability to seek an appeal of the sentence, and Mr. Cruz, you can provide Mr. Roby with his.
He's been provided in here.
Mr. Roby, you are.
Yes.
Truce, we're ready on Strasburg's case.
Yes, I'm ready on this trust.
President, come forward, please. This is file number 265566 and 265567. The record should reflect Mr. Strasburg present in the courtroom. Counsel, can put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of Sarah Crawford. Your Honor, I think we have a resolution that resolves all the pending matters before Your Honor. 5566, which I believe is the controlled substance case. There would be an offer to plead to possession of a controlled substance analog at 2-year maximum. Okay, so that's an added count too.
The PAT code is 333.74032B-A for that charge.
And actually, just for the record, that is file 5567.
Oh, I'm sorry.
Yep.
That's okay.
And 5566, the offer is an attempted RNO.
That is correct, Your Honor. So that's a 1-year maximum.
And one of those counts for both.
One.
One attempt. And then, Your Honor, by necessity, plea to a violation of law would be a probation violation under case 24529. Have to notice on that. Or you can set it at the beginning.
Okay. And then we would set all of these for sentencing at a separate date?
Yes, and I would ask you to do them all at the same time for efficiency.
Ms. Strasburg, is that a correct statement of the agreement
Yes,
as
sir.
you understand it?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand. Ms. Strasburg, are you currently on any kind of probation or parole?
Yes, I am.
And I mean, aside from the one that we're talking about.
No, no.
All right, so you understand that by pleading guilty, to one count of attempted resisting or obstructing, that the maximum possible penalty you can face would be 1 year?
Mhm.
Just need to say yes or no.
Yes,
And then by pleading guilty, the added count of possession of analogs, that's maximum penalty of up to 2 years.
yes,
And then you understand that by pleading guilty to those charges, that is going to result in essentially an acknowledgement that you violated your probation as well. You understand?
yes, I do.
And it looks like the maximum penalty, is that a 4-year? on that one?
So it looks like possession of meth, so it would be 10 years.
Okay, so,
I believe it is possession, not your honor.
okay. So that could subject you to the maximum penalty on your underlying charge that you were on probation for as well.
Yes, sir.
With all of those things in mind, what is your plea to those charges today?
Guilty.
Judge,
So-
I'm sorry, it is a 4-year. My
Okay, she
apologies.
pled to a lesser charge.
Yes, she did. Sorry,
So it'd be 4 years.
Mhm.
was 7411, Judge.
Okay. All right, so Ms. Strasburg, you do have certain rights. I'm gonna go through those with you.
Okay.
You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, and to not have that silence used against you. The right to testify at a trial yourself if you want. Do you understand all those rights?
Yes, I do.
And do you understand that you'd be giving up and waiving all of those rights by pleading guilty?
Yes, I do.
In terms of your probation violation, you also have the right to have a hearing as to whether or not you violated your probation. Do you understand that you'd be giving up that right as well?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. And they can say no, and then that would be the end of your appeal. Do you understand?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here in court today?
no.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty because you are guilty?
yes,
So, first of all, the possession charge, this indicates that happened on October 20th.
yes, sir.
On that date, were you present here in Crawford County?
Yes.
And at that time, did you have possession of some cocaine?
It was it was a residue on something, but yes.
Was it a narcotic?
Yes, it was a narcotic.
Okay, all right. And that was on, what was the residue?
On a food in my car. I was in the passenger seat, it was in a bag on floor.
And was that spoon used to ingest that substance?
Not by me, but it had to have been used with for something. But I had reported to probation the very next morning and
And I'm not asking whether you used it or not, but I mean. is that
no,
the purpose of that?
well, it had to have been, yes,
All right. And so that was in your vehicle and it had ended up having some.
Yes,
amount of
correct.
controlled substance.
Yes, Your Honor.
And then the other incident that happened on January 13th of 2026, is that correct? When you encountered the police officer?
Yes, yes,
Did that happen here in Crawford County?
yes, sir, at my residence.
Okay. Did that involve Crawford County deputy?
Yes, it did.
And when you encountered that deputy, did you know that that person was there performing their duties?
Yes, I did.
And
I,
what did you do to try to interfere with that?
well, I went to turn, she put a cigarette out, so I went and bring the officer. And they thought I was resisting. So,
I don't know this. I just haven't seen a police report or anything. Sure, yeah, Thompson, is there any other facts that you flesh out there?
At the point that they're arresting you, did they order you to put your hands behind your back?
yes,
And is it
And-
true that you did not immediately comply with that lawful order?
it is because I had to put, I didn't want to burn anybody, so I went to turn and put the cigarette out first instead of just putting my hands behind my back.
And then when they grabbed your arms, you weren't immediately putting them behind your back? Is that true?
No, because I just said, don't want to burn nobody.
And that happened here in Crawford County as well, you said.
Yes,
Ms. Koch, are you satisfied with the factual basis as to those two charges?
Yes.
Mr. Thompson?
Yes.
All right. Ms. Koch, are the people, oh, I have a couple more questions.
Yeah.
I'm sorry. When the incident on October 29th of 2025 happened involving the substance on the spoon,
yeah,
were you on probation here in Crawford?
yes, I was.
And were you aware that one of the conditions of your probation was that you were to not violate state law in any way, that you were to not use or possess any controlled substance?
Yes, sir.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Thompson?
No.
Ms. Koch, are the people satisfied that the court has complied with statute and court will undertake this plea?
Yes.
Mr. Thompson?
Yes.
Ms. Strasburg, as to the two new charges, the court finds the plea is knowing, voluntary, accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of each of those charges. The court also finds, based on your testimony, that it would provide a factual basis to support a finding that you violated probation. As alleged, counts 1 and 2, the court will accept your plea as to all three issues. As I said, we'll set this matter for sentencing hearing. You're going to meet with, I think, Mr. McDonough here briefly, and then just make sure that you stay in touch with Mr. Thompson before the sentencing.
Absolutely. Thank you.
Yeah, Ms. Wall present. On the record in People versus Ashley Wall, file number 265559, the record should reflect Ms. Wall's presence in the courtroom today. I'd like to have
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Ashley Wall.
This is the date and time set for a sentencing hearing in this matter. Ms. Wall, did you have an adequate opportunity to go through the report and discuss that with Mr. Thompson?
Yes, I have, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
No.
Are there any challenges to the scoring of the guidelines?
No.
Ms. Koch, do the people have any additions, deletions, or corrections?
No.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
And I think this is the kind of case that 7411 was meant for. She has no juvenile record. She has 2 misdemeanors. They appear to be a retail fraud and harboring a misdemeanor. She's in active substance abuse treatment. She is complying with her health needs and dealing with the transfers. She has stable housing. I realize that she has a case that they're dealing with in Georgia that is substance abuse, but I don't think it precludes her from 7411 because it's not gotten to the conviction point. So I think she would be a good candidate. I think the recommendation is appropriate. Thank you.
Thank you, Mr. Thompson.
Your Honor, I echo the prosecutor's comments. I think this is a very good case for 7411. I think Ms. Wall was very, upfront and honest. Was the way I took the report to the agent. She admitted, the struggle she's had, but she's also, put a lot of effort into that substance abuse treatment with the methadone and with the Suboxone. She had, a relapse here, and that happens as people go through recovery, but I think we should keep her on that recovery path. And I hope she's able to continue to maintain her sobriety. I think 7411 will help her towards that end. And then, obviously a lot of the responsibility lies with her. And I believe she will continue to put forward a really good effort. Thank you.
Thank you. Ms. Wall, is there anything you wanted to say here?
No, Your Honor.
Ms. Wall, I did read through the report before the hearing today. So I'm familiar with the circumstances that bring you here before the court. I'm also familiar with your background, generally prior history and so forth. And when I read the recommendation and then read the report, I do think it's an appropriate recommendation. I think 7411 is certainly appropriate under these circumstances. I think given your efforts, that there is certainly a chance of rehabilitation coming forward from this. And I agree with what the attorneys have said in terms of the 7411 statute that would allow you to have this come off your public record if you successfully complete probation. I agree with them that you're the type of person that could do well on that, and that's designed for, and I hope that that's the way that it goes. So I am going to follow that recommendation. The court is going to sentence you to 18 months of probation pursuant to 7411. The court is going to adopt as the terms of your probation all the terms and conditions listed in the report. And that, of course, includes that you're not use or possess any controlled substances unless they're prescribed to you. An important thing for you to know as well under these circumstances, especially, is that not only can you not use or possess them, you can't be with anybody else who's using or possessing. That's going to violate the probation as quickly as you got it yourself. So it's important that you keep that in mind and go forward in terms of those that you're associated with. The court is going to order that you pay a crime victims assessment of $130 for a cost of $325, attorney fees of $50, a testing fee of $60, and a $68 state cost. Because this is pursuant to the court is going to order that you serve 2 days in the Crawford County Jail with credit for 2 days served. Because this is pursuant to 7411, there are no written appellate rights at this time. But you need to make sure that you check in with Mr. Powell that you're in, or you can do the supervising agent.
Yes, Judge, until I transfer.
Okay, so just make sure you check in with Mr. McDowell before you leave here today.
Okay.
Do you have any questions at all?
Nope. No, Your Honor, but you won't see me here again.
All right, good. Thank you.
Thank you.
Okay, Mr. Jackson, is he present? Jackson?
No, Your Honor.
All right, the court calls People versus Christopher Jackson, file number 255496. This hearing is set for 10:45. It's now 11 o'clock. Mr. Jackson apparently failed to appear in June. We did have a jury trial that had been scheduled for June 10th. Have you had any contacts with him?
I have, I don't know why he's not here today, but he did not appear last time, and I know he has a lot of transportation difficulties.
Ms. Cullen?
No, I'm asking for a bench warrant.
All Based on Mr. Jackson's repeated failures to appear, the court will request the people prepare a bench warrant. Once he's arrested and brought before the court, will proceed further with this case. People versus Beckman, Jeremiah Beckman.
Sierra Folk on behalf of the. This isn't my case.
Mr. Beckman, come right up to the podium there. Please, the record should reflect Mr. Beckman's present here in the courtroom today.
Yeah, this is an attorney general case. I apologize.
I see. All right, counsel, can you put your appearance on the record, please, from the AG's office?
Christina Beta on behalf of the Attorney General.
Thank you. Ms. Beta, we are on the record now in People versus Jeremiah Beckman. Mr. Beckman's present here in the courtroom today at the podium along with his counsel, Mr. Thompson. This is set for a status conference in this matter today. Mr. Thompson, can you tell me where things are at with this file?
Yeah, Mr. Beckman entered a plea about a year ago. He has been paying his child support since then. The balance has gone down. It has not gone down to that number that we suggested or that we had agreed would be enough to get it down to a misdemeanor. But he has been making regular payments. Your Honor, I spoke to his LLC record last week. Apparently he's paying another $1,200 today, so you have to do the math on that. I think it's right around, did you tell your current balance?
No.
Sorry, I don't want to get it wrong. Okay. I believe it's between 18 and 19,000 now with this current payment that I just got handed. But he has been making payments, doing everything literally.
All right, Ms. Beta, what is the people's position here today?
I would basically echo Mr. Beckman's attorney's statements. He has been making consistent payments, but they've not been sufficient to pay down the arrearage adequately to qualify for the delayed sentence deal. I have the current balance being $19,413.50. To qualify for the attempt, it has to be down to $13,900. So we're quite a ways from there. So we leave it to the court's discretion on how to proceed.
And Your Honor, I would just indicate Mr. Beckman has a payment. It looks like it's dated today, so I don't know if that's counsel's calculations that you just referenced.
All right, let's just take a short recess. Mr. Beckman, you can just stay at council table there. Ms. Beta, I'm going to have you just remain connected. I just need about 3 minutes here to check some paperwork, okay?
Okay.
All right. Okay, we have everybody connected again. We're back on the record in Mr. Beckman's case. So I did have a chance to review the account, and I agree with counsel in terms of their statements of the payments that have been made. And so, Ms. Beta, I guess, we're at the end of the delay period. What are the people asking the court to do today in terms of sentencing?
We would ask that the people would sentence the defendant based on how he has pled.
Okay, but I mean, in terms of, are you asking the court to impose additional jail time?
No.
Okay. All right, thank you. Mr. Thompson, you and your client can come back up to the podium. Mr. Thompson, anything you want to say regarding sentencing?
Your Honor, I just handed the court the payment slip, $1,200, which is a lot of money for some of Mr. Beckman's position. He is taking his balance down. I believe that that most recent payment is down is at $18,200. Approximate amount when this case started was over $28,000. So Mr. Beckman, despite his limitations, despite his inability to work full time, he has paid down his child support. I think the court looks at what's happened over the last 24 months. He's going above and beyond. And I would certainly acknowledge that would be after a period of time where he's not fulfilling his child support obligations. But, I think what this court was looking for Mr. Beckman to do was to give his best efforts. And I believe he has. I think $10,000 down on the arrears and not even just keeping up with his payments, but also bringing it down $10,000 is a very significant financial load for Mr. Beckman. It would be for a lot of people. I think the court should credit that. Thank you.
All right, thank you. Mr. Beckman, was there anything you wanted to say today?
I've had a bunch of back problems and I have to go for another back surgery. I've been on SSI since 2024. I get $900 a month and that's what I get paid at the end of the month. I pay $500 every month when it comes in, and it's just been pretty hard for me to get an extravagant amount of money to come in here to get down lower as fast as you guys wanted me to. That's all.
So I did read through the report, to kind of refamiliarize myself with your case. I did get an update regarding your progress over the past year. And of course, we talked about here today, the additional payment that was made today. Looking at the circumstances as a whole, it does appear that you've made good faith efforts to pay that down to the amount that could have gotten you the benefit of the plea bargain in this case. You have made significant efforts over the past year to pay it down as much as you could. Given the limitations of your circumstances, the court also notes that you were being supervised through Saginaw County. They report that you didn't have any, didn't violate any of the other terms of the delay during the time that you didn't have any new contacts with law enforcement. And they confirm your ongoing medical issues. So the court finds that additional jail time is not appropriate. The guideline range is 0 to 3. So the court is not going to impose any additional jail time because you have made good faith efforts and paid as much as I think you probably could have during this period of time. The penalty that you're going to face is essentially having this felony charge on the record, as opposed to the misdemeanor charge, which you would have gotten had you been able to pay it down enough. And the court finds that that is a sufficient penalty under these circumstances. So the court is going to discharge you unsuccessfully from the delay. The court will order that you serve 1 day in jail with credit for 1 day served. And the court will reserve any other outstanding fines and costs, including the balance of child support owed, which of course you're still under that obligation. Mr. Beckman doesn't relieve you of that. You do have the ability to seek an appeal of the sentence. Mr. Thompson, we've been able.
I don't see that I have them on the table, Your Honor. I apologize.
Okay. So Mr. Beckman, you have the ability to seek an appeal. We'll provide those appellate rights to you. Mr. Thompson, I'll ask Sarah to get those to you. When she gets back, and can you get those to Mr. Beckman?
I will, thank you.
And that's all for today, Mr. Beckman. Thank you.
Thank you.
Your Honor, may I ask what the new balance is?
I'm sorry, what's that?
May I ask what the new balance is?
I don't have that number in front of me. I'm sure if you contact our friend at the court, they would be able to provide that to you.
Thank you, Your Honor.
Okay, thank you, Ms. Beta. You're free to disconnect at this time.
Thank you.
People versus Mallmeister, number 265556.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of the defendant, Dave Moment.
And Mr. Thompson, how do we want to proceed?
Your Honor, if I get a few more moments to speak with my client.
Yes, Mr. Vogel, are you ready with your file, Mr. Green? Mr. Vogel, are you ready with your,
Yes, Your Honor.
Mr. Green? Okay, can I report, Mr. Green, you can around your podium there, please. Thanks. We're on the record in People versus Mark Green. This is file number 265552. The record should reflect Mr. Green is present here in court today. If I could have counsel.
Sierra Cook on behalf of the people.
John Vogel on behalf of Mr. Green, Your Honor, who's just executing the notice of
Yes. And Mr. Green, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Vogel about that? Yes, sir. Okay, Mr. Vogel, are there any additions, deletions, or corrections to that report?
Yes, Your Honor. Going over the report with my client, he indicated that on the very first page under jail credit that that's inaccurate. He was originally arrested back on March 14th. And he said he did 3 days and then he bonded out and then went back into jail at the bond hearing because he failed to appear. And then so he figured he had 14 days in May, and then there's June, a month, and July for a total of 56 days of incarceration, not 117. And that also appears on the very next page on the PSI there, and then the second to last page. I went through it, yeah, and there's another jail credit box there, but
okay,
otherwise it's accurate.
All right.
Your Honor, I think that sounds accurate. Mr. McFall isn't able to confirm one way or another because it was done out of county.
I know that he was out on bond for a period of time, so that makes sense to me. That he hasn't been in that entire time since March. So the court will modify PSI to reflect 56 days of credit. So anywhere where that's mentioned. Correction. And you said no other corrections, Mr. Vogel?
That's correct. Scoring's accurate.
Okay. Thank you. Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, this PSI is interesting in that he talks about, the agent talks about how it's very unlikely that there's going to be any effect of this sentence because he doesn't seem to realize he has any type of problem. You look at his criminal history and it's littered with all these offenses involving alcohol. He's got several drunk drivings. He went to sobriety court program and then he had some violations there, but ultimately was successful in that. And then, he's driving around with an open intox, and he has these old, they're very old, but they're delivery cases that involve narcotics. I don't see how he doesn't see that this is a major problem. This was a lot of substances. His guidelines are high. I mean, he's 58 years old. but he has 8 misdemeanors and 3 felonies, and he already had delivery cases. You know, I think middle to high end of the guidelines is appropriate. Thank you.
Thank you, Mr. Vogel. Anything on behalf of your client for allocation?
Thank you, Your Honor. One thing I guess I could have mentioned, I forgot, but that wasn't in the report, but was in the lab report, is that as far as the possession, he had a .0503, so 5/100ths of a percentage of a gram, so just trace amounts. And of course, he pled to possession of 25 grams or less. So on that scale, it's not like somebody who had 8 grams or 15 grams or 20 grams. So it was not a usable amount, frankly, to do anything to anybody. But I would say that in talking to Mr. Green a few times that I have, that I think the probation agent may have misread that. Maybe up to this point that day, he didn't realize that the effect that was having on him. But having sat in jail for 56 days, he indicated to me he's too old for this. He's older now. As prosecutor pointed out, those 2 drug charges, possession, he did do a substantial amount of jail time for that back when he was doing that. At any rate, he has a business. It's called the Hubbard Lake Home Improvement, which was pointed out. He's been doing that for 12 years. He's been a volunteer at the Hubbard Lake Sportsman Association for building fishery shelters for the biological team. He also sponsors some charity golf outings every year and a bobber hunt for Down syndrome people. Once a year, he works with the Hubbard Lake Home Improvement Supply Company, the supplier that he gets materials from, and they find elderly families, veterans, or people that are just in need, and they provide the materials, and then Mark and his 2 employees, they'll volunteer their time to help those people out. So he provides the building crew. He told me that he obviously hates to be in jail and do that jail time, and I think he's learned his lesson now. So he told me I'm just too old for this. So I think it has sunk in finally with the time in jail, and I would ask, given the low amount here of drugs involved, that maybe time served would be appropriate. Thank you.
All right, thank you, Mr. Green. Is there anything you wanted to say today?
Yeah, just to reiterate what my attorney mentioned is, yeah, the time that I've had to sit these last couple of months is, it's really sunk in and brought the shame, the disgust, the disgrace. I'm just, maybe 59 years old. I'm just getting too old for it. And I just hope the court can see that, and I can get back to my community and start doing some good.
Mr. Green, I did read through the report, so I'm familiar with all the circumstances that bring you before the court here today. There's also a lot of information in that report, I think, as the lawyers have alluded to, about your background and your history and so forth, your prior record, and just you as a person generally. I take all of that information into account, along with what the lawyers and yourself had to say here today. I agree with Mr. Vogel. I mean, the amount that was found wasn't substantial. I think the more concerning thing is all the other stuff, scales, baggies, glass tubes, measuring cups, scissors, all of that stuff is indications of delivery. Have that stuff if they're just having personal use amounts. So while the amount that you were found with wasn't substantial, circumstances certainly indicate at least the potential that there was distributing going on. And that's what's concerning the court, because that's what's going on. It's allowing the substance to get into the community and for others to use it to be harmed by it. Your past record isn't great either. You've been in jail 5 prior jail sentences, 5 prior probationary sentences, and 1 prior prison sentence. So you've had lots of opportunities to realize that this is not the way you want to go. Maybe this is the time that does it based on your age and your other circumstances. I don't know. But the guidelines are 0 to 21. The court would be within the guidelines to impose a prison sentence I don't think based on all the circumstances that that's warranted. But I also don't think a sentence at the low end or time served is warranted either based on conduct here and your past history. Court finds that a sentence in the middle of the guidelines is appropriate. You get accountable for your actions. In this case, provides for a degree of punishment consequence to you, but also recognizes the mitigating factors that Mr. Vogel has outlined. Court is going to sentence, and I don't find that probation would be appropriate given 5 prior terms on probation. I don't think would be in the community's interest or frankly your interest to do another term of probation. So the court is going to order a straight jail sentence of 12 months or will grant 56 days of credit. Or will order a crime victim's assessment of $130, court costs of $325, DNA testing fee is $60, $68 state costs. You do have the ability to appeal this sentence. Mr. Vogel has provided you with those papers that will explain to you how to file for appeal and how to request a court-appointed lawyer if you want to do that. At this time, you are remanded to the custody of counsel. Yeah. Mr. Thompson.
If you're ready, I'm all extra.
Okay. Is Mr. Cronk here as well?
Mr. Cronk is here as well.
Let's take, are you ready on Mr. Cronk's case?
Yes.
Let's take Mr. Cronk's case, People versus Cronk, file number 265563.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of Kyle Cronk. Let's stand at the podium.
Mr. Cronk is present here in the courtroom today. Mr. Thompson.
Your Honor, I believe the prosecutor and I are supposed to be asking you for a little bit more time on this. The reason being, there's 3 defendants here. So there's kind of a 3-part negotiation going on, and I think we're close to a deal, but we're not quite there. So I think it would be in the interest of justice to adjourn this out. Thank you. Let's go.
Yeah, I think that would be appropriate. We are working on an offer. We've talked about it numerous times. It's not like this file has gotten lost. We discuss it regularly, but there's some things happening with the other cases that are kind of all coming into play. So I would ask to adjourn this one out too.
Mr. Cronk, have you had an opportunity to speak with Mr. Thompson about this adjournment?
This is all new to me, so not really.
Do you have any objection to that? Do you want to talk to him about that more before I grant the adjournment?
Kind of, yeah.
Why don't you guys just, can you just have a conversation again? So.
I believe we're gonna be requesting the adjournment.
Sure. Mr. Cronk, you don't have any objection to that? No. Okay, all right. When do you want the court to set this next?
I would say 6 weeks, Your Honor. To be honest, he's trying to obtain a better offer, but we have some other things that we need to figure out first. And so we have to wait for the other cases.
Okay. Any objection to that? No. So, Mr. Cronk, between now, we'll send you notice of the date of your next hearing. Between now and then, just make sure that you stay in touch with Mr. Thompson so that you're prepared to go forward then, okay? All right, thank you, that's all. If Mr. Malmeister can come back forward, please. Go back on the record and file number 265556, Mr. Thompson.
Thank you, Your Honor. We have an offer to resolve this case. The prosecutor would offer to dismiss count 1. Count 2 is the 2 drug charges. And dismiss the habitual offender notice. If Mr. Malmeister, I'm sorry, count 1 and the habitual offender notice. If Mr. Malmeister pled guilty to counts 2, 3, and 4. Count 2 is carrying a concealed weapon, 5-year maximum. Count 3 is operating with license suspended, and count 4 is unlawful use of a license plate.
Is that a correct statement of the offer?
It is.
Mr. Malmeister, have you had an adequate opportunity to speak with Mr. Thompson about this agreement?
Yes, I have, Your Honor.
Is that how you wanted to proceed today?
Yes, it is, Your Honor.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Malmeister, are you currently on any kind of probation or parole?
No, Your Honor.
You understand that by pleading guilty to carrying a concealed weapon, that carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine and mandatory forfeiture of that weapon?
Yes, Your Honor.
And by pleading guilty to operating with a suspended license as a second or subsequent offense, that's a misdemeanor that carries with it a maximum penalty of 1 year and or a $1,000 fine. Do you understand that?
Yes, Your Honor.
And that unlawful use of a license plate is a misdemeanor that carries with it a maximum penalty of 90 days and or a $100 fine. Do you understand that?
Yes, Your Honor.
With all of those potential penalties in mind, what is your plea to each of those charges today?
I'm guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear that case. If they said no, then you couldn't go any further with that appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, it is, Your Honor.
Are you pleading guilty because you are actually guilty?
Yes, Your Honor.
The information I have indicates this happened back on March 14th of 2026. Is that correct? Date?
Yes, it is.
Okay. And this was a circumstance where you got stopped by the police here in Crawford County. Is that correct?
Yes.
That happened on North Downriver Road here in Crawford County.
Yes.
At that time, did you have a concealed weapon, a double-edged, non-folding knife for stabbing?
Yes, Your Honor.
Did you have any license or other legal authorization to carry that weapon in a concealed manner?
No, Your Honor.
And the vehicle that you were operating the vehicle at that time?
Yes, Your Honor.
Did you have a suspended license at that time?
Yes, I did.
Had you previously been convicted of operating with a suspended license back in 2020?
Yes, Your Honor, that was a tractor, actually, not a vehicle.
Okay. But you were convicted of
Yes,
that?
yes, I was.
Did the vehicle that you were driving that day that had a license plate that didn't belong to that vehicle on it, is that correct?
Yes, Your Honor.
Ms. Coker, are you satisfied with the factual basis?
Yes.
Mr. Thompson?
Yes.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and rule and taken their excuse?
Yes, Your Honor.
Yes, Your Honor.
Mr. Allmeister, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Thompson prior to that. Before you leave today, you're going to meet with the probation officer to set up a time for a pre-sentence report. Do you have any questions?
No, Your Honor.
Thank you, that's all.
Your Honor, in terms of sentencing, the date, Mr. Malmeister advised me that he has a surgery scheduled for August 17th. Is August the month we don't have the bid motion sentencing day?
Yes.
Okay.
It's a 100 knee replacement, Your Honor.
Okay, so this sentencing is likely to be set for prior to the surgery.
Okay.
In August, or beginning of August.
Thank you. Okay. All right, thank you. Hey, you're gonna talk to this lady up. Your Honor, in terms of the docket, Mr. Trush finds himself detained in Otsego County. Asked that I cover Mr. Bunker's sentencing.
Okay. We will take that in just a moment.
Is that okay with you?
No, so special prosecutor.
All right, we're going to go on the record now in People versus Price. This is file number 255467. If I could have counsel put your appearances on, please.
Madonna Schultz, Ogama County Prosecutor, sitting in Crawford County by assignment.
Jesse Williams, Your Honor, representing Mr. Glenn Price.
All right, this is set as a status
on time.
Set as a status conference here today. The record should reflect Mr. Price is also present by Zoom video. This is set as a status conference today. The court had previously issued an order following a hearing that we had in May. And so I guess Mr. Williams, I'll address you first. Can you tell me kind of where things are at in light of the court's order and where you're at in terms of the defense at this time?
Your Honor, we did conduct the interviews that we thought were appropriate. I'm still hoping that the Michigan Indigent Defense in that county will pay us whatever the fee is an assignment attorney would get, but that's not the court's problem. It's something I'm hoping ultimately happens. And we're prepared to schedule a trial regardless and move forward in that direction.
All right, Mr. Williams, what would you like to request for a time frame for the court to set the new date?
Your Honor, I've been in contact with Ms. Schultz. We both, I think September or October is something we both would request the court to give us available dates for those months.
Okay, Ms. Schultz?
September, I think your trial schedule is earlier in the month, correct?
Yes.
Okay, then September would work for me.
Okay. How about Would September or October work?
Um, no, I'm out actually, in early October, end of
Okay.
September.
So if it's not September, it would need to be, I'm gonna shoot for September, but if I can't do that, then we would be in November then.
Okay, that would work.
And Ms. Schultz, are you still anticipating that a 2-day trial would be sufficient?
Yes.
Okay, Mr. Williams?
I agree, Your Honor. I think we both know the witnesses. We've been we're working together. That.
Okay. All right, so the court will get this scheduled according to what we've discussed here today. The court will send out those new trial dates to all sides. I will conduct a final status conference on my motion day immediately prior to the trial dates. Once we have that, that will again be a plea and motion cutoff. So to the extent there are further plea negotiations, that would be the last day to enter into a plea. And to the extent that there are any motions that would need to be filed by either side, they would need to be filed and heard no later than the date of that final conference. Ms. Schultz, are there any other dates that I can address for your side today?
No, Your Honor.
Mr. Williams?
Just does the court know what September date we're looking at? I'm just trying to.
I don't have my calendar in front of me. I believe my my trial week is the second week of the month here in Crawford.
Okay. That's helpful. All right. Thank you.
Okay. All right. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
It'll be September 14th to 18th is your trial week that week.
Thank you.
Okay, thank you. Everybody's free to disconnect on this file at this time.
Thank you, Your Honor.
Mr. Bunker, if you'd like to come forward, please.
Okay.
We're on the record in People versus Bunker. This is file number 265553. The record should reflect Mr. Bunker's presence here in the courtroom today. Mr. Bunker, I know Mr. Trush is your attorney, correct?
Yes, Your Honor.
Did you have a chance to go through the pre-sentence report with him?
Yes.
Okay. Mr. Thompson is here today. Do you have any objection with him representing you?
No, Your Honor.
Did you want to have any time to speak with him before we go forward?
No, Your Honor.
Mr. Thompson, I know you're just jumping in here. Did Mr. Trush make you aware of any
He
corrections or
did.
challenges?
Yes, there are no corrections or challenges. He did send me the pre-sentence report. So no corrections or additions or deletions, Your Honor.
Okay. And no scoring issues?
Correct.
Thank you. Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, it's a misdemeanor file, Your Honor.
I'm sorry, what's that?
It's a misdemeanor file, Your Honor.
Oh, which I can see that. Do you have any victims that wish to address the court today?
Yes, Your Honor.
Okay. Mr. Bunker, could you have a seat over there, please? Sir, if you come forward, thank you. Thanks for your patience. I know you've been waiting.
Oh, sure, no problem.
Can you tell me your name?
First name's Lee, middle name Michael, last name Caitlin.
Okay. And can you tell me how you're connected to this?
It was my property, my house that was broken into. It was my car that was, truck that was stolen, along with dirt bikes and other items, four-wheelers and stuff out of my garage.
Okay. What is it that you would like to say?
Just that what was stolen was more than just items. It was memories, it was promises, it was the safety and security of other individuals. When I say memories, the quad that was stolen, my daughter, 5 years old, learned how to ride that. We're hoping that her daughter someday would maybe get to ride the same quad that her mom learned to ride on. Also too, the travel trailer that was stolen had my daughter's diaries in it from a trip that she'd taken cross country. Those were destroyed or just gotten rid of when the trailer was stolen. Promises. There was a knife collection, a case knife collection that was at least 60 years old with multiple knives. One was from my grandfather. Other 6 or 7 were from a trapper here in Grayling, who I convinced to sell me the knives with the promise that I would never get rid of them. Those were stolen. Safety and the promise of safety and security, I mean, that was stolen with the guns that are now, the 2 shotguns that are out there in the community. Who knows how those will be used. My security has been stolen. I mean, now we've owned that property for 45 years approximately. I can't take for granted now that, my security, I'm safe in that house any longer. And then the community also too, their safety with, stolen guns being out wherever they may be. So I just want to say that, this has had a big effect on a lot of people. Also too, even though I had insurance, I wasn't made fully whole. My dirt bike, the quad, and some other items I didn't have insurance on. So I'm at a loss of about $2,000 to $2,500 out of pocket. Not to mention travel experience, traveling to come from California to be here. What else? That's about all I have to really say.
Thank you.
But it's been a big issue as far as our safety, our security.
Ms. Coe, I'll hear you and Mr. Ms. Coe.
Yes, I've struggled with the allocation. Professionally, I've known Mr. Bunker through my job here for a while. He mostly had minor offenses, had done successful probation in the past. And then I'm not sure what happened to Mr. Bunker. I believe he probably got involved with his co-defendant in this case and things went downhill. And I heard Mr. Bunker's name pretty repeatedly. He had, firearms reckless use, use of methamphetamine, a domestic violence. I think that was with his grandpa or
with my father.
That he was living with, who wanted to have contact with him and he was taking care of him. So all of a sudden, I just heard about Mr. Bunker all the time when I hadn't heard about him at all. This case took a long time to investigate because it was hard to identify who the suspects were. For a long time, there wasn't any suspects. They were able to narrow it down, and I do not think Mr. Bunker was the ringleader of this theft ring. I do, however, think that he probably knew that his co-defendant was stealing those items rather than him helping him pull them. He was cooperative with law enforcement when they interviewed him. He was honest and forthcoming. He has agreed to testify truthfully to what happened in this case, which is an important part of admitting responsibility. But also we have this man and his daughter whose all of their stuff were stolen. To what extent Mr. Bunker was involved in all of the items stolen or just that things that he admitted, I don't know that we'll actually ever know the answer to that question. I would ask the court to order restitution, joint and several with any co-defendants in the amount of $2,500. We had asked the defendant to submit the victim to submit something, but we did not have anything. I didn't have a dollar amount until today of what those losses were beyond his insurance. And in terms of jail, I would defer to the court as to what's appropriate. Stealing stuff from people's property is a crime. I think it should be punished. Taking responsibility and admitting what you did is the flip side of that coin in terms of possibly not being involved in law enforcement investigations in the future. So that's all I have to say. Thank you.
Can you tell me the restitution amount again?
I would ask for $2,500. I think that's what the victim just identified, that his insurance didn't cover beyond of items that were stolen. It would be joint and several with Mr. Barshaw if he is convicted and Mr. Kronk if he is convicted.
Mr. Thompson.
Thank you, Your Honor. I think the report is thorough. I think it describes the circumstances very well. I think it explains Mr. Bunker's role, which is very much a mitigating factor role in this, and his culpability don't necessarily match the total loss that the victim suffered. I don't object or disagree with anything that this gentleman was telling the court today. But Mr. Bunker admitted his role, which is a small role, and I do think that should carry some weight, and do believe the recommendation is appropriate here, Your Honor. Would ask the court to adopt it. Thank you.
Thank you, Mr. Bunker. Anything you wanted to say?
No, Your Honor.
All right, well, I did read through the report, so I'm familiar with the circumstances that bring forth the court today. Sir, I want to thank you for coming in. See what's on paper. It's sometimes hard to see how it actually affects people. And certainly, an inventory of the items doesn't give me any kind of insight into what those items actually mean. So it's really helpful for you to come in and done that to me. It's not an easy thing to do, to have to come in and say you're a victim of a crime and stand in court, talk about it. So I appreciate you doing that. Mr. Bunker, I understand that your role in this was more limited than perhaps some of the other individuals that are alleged to have been involved. But I also am satisfied, based on what I read, based on my knowledge of this incident and the other individuals, that you had to know kind of what was going on here and that you participated in it. And I hope you listened to what this gentleman had to say. Do you have kids yet?
No.
One of the things he said really struck a chord with me, and that's, he owned this four-wheeler that the rest of us is just a vehicle that you get on and drive around. But when you have children who learn to ride something like that, or whether it's a bike or anything else, anytime you look at that, especially once those kids are grown, you see that little child riding on it. And to be able to have that and have another generation learn on that same vehicle that your mother learned to ride on, that means something to you as a person.
Can I add in something? Well, I only been there 3 times, and the 3 times he told me it was his family's property. And so I was just like, I didn't know him very long, so I believed him. And it turned out to be a lie now, since I'm standing up here now.
Well, it definitely turned out to be a lie, but I don't know, you've been around the block enough times to know that somebody like the people you were involved with.
No, it was my first time ever being involved with people like that.
Let's just say I don't believe you. It's my position. And clearly you're not really listening to what I'm having to say here. So that's fine. As I'm saying before, for your benefit, I understand where you're coming from. So when I look at your involvement, again, I don't think, regardless, that it was as extensive. I think you were involved in something that you either knew or should have known what was going on. And this charge you pled to calls for up to a year in jail. I don't think a year is appropriate, given your level of involvement. You're not the most culpable person in this situation. But I do think some level of punishment is called for here. And so the court finds that, number one, probation is appropriate. I think some monitoring and some supervision for a period of time is appropriate to make sure that you're not engaging in any illegal activity is called for, so the court is going to place you on probation for a period of 12 months. The court is going to adopt as the conditions of that probation, all the terms and conditions listed in this report. The court is going to order that you serve 90 days in the Crawford County Jail. You have credit for 1 day served. And that's in the lower third of what the court could sentence you to. I think it takes into account your wrongful conduct, but also recognizes, again, that you were not most culpable in this situation. The court is going to order restitution in the amount of $2,500. That's payable to the Crawford County Clerk to be dispersed to the victim in this case. That's to be joint several with either Mr. Kronk and or Mr. Barshaw. The court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $50 state cost. You have the ability to seek an appeal of this sentence. If you wanted to file for an appeal, you would need to do that within the next 21 days. If you have questions about that, either Mr. Thompson or Mr. Church will be able to answer any questions you have. Other than that, you are in to the custody of the county at this time. You go with the court officer here, please. And, Mr. Thompson, are you ready with Mr. Rickman's case?
Yes, thank you.
Mr. Rickman, the last case on the docket this morning. That's okay.
Good morning, Your Honor.
Morning.
Yeah, this is
Good morning, everybody.
also an AG case. They had contacted me and asked me if I objected if they appeared by Zoom. I said they didn't. That's how I would anticipate seeing them today.
Yeah, I would agree. I thought that's. Well, I mean, we're well past the time. Mr. Thompson, how do you want to proceed? If they're not present, I don't know that I would even know who to contact.
And I believe they're probably required to be present, so
I would say so.
you know, obviously, Mr. Rickman's here, he's doing everything he's supposed to do, but I don't believe the court's in a position where it can disregard their absence.
Okay, so Mr. Rickman.
Yes, sir.
There's been some kind of.
Snafu?
Yes.
Yes, sir.
So unfortunately, what that means is you're gonna have to come back a different day.
It's okay.
But I will note that you were present.
I'm just gonna keep doing the right thing and doing everything I'm supposed to, and I'm trying to get my family back together and just made a mistake.
Okay, sounds good. So just make sure you stay in touch with Mr. Thompson.
I had a quick question since
Yes.
Doug's here and everybody. Were you able to access the assessment from the mental health? Because that was one of my stipulations that within 10 days I had to schedule it. Within 10 days I had it.
Okay, great.
And there was no findings for any mental, no substantial mental illness, no damage to be treated. And you know, we already knew that. It was this big thing with the friend of the court where my daughter's mother had just made big allegations. And then.
So do you have that paper copy?
I do it at my home.
Okay, so why don't, let's head out and talk about it in private.
Okay. Okay, sorry.
Go ahead, that's fine. But yeah, that's a conversation.
I just wanted to make sure that that was like found or.
Mr. Thompson will make sure that.
Yeah, I'll make sure we have the exact same thing.
Okay, thank you. Thank you, Your Honor.
Thank you.